me now to discuss is Richard Schoenstein. He's a legal analyst and trial lawyer. Richard, good morning. Good to see you once again. So let's start with the text messages. Just how incriminating are these text messages that were sent to his roommate? It would seem like an open and shut case because he essentially said he did it and went into detail about the gun and other key evidence.
Well, they are as incriminating as any evidence like that I've ever seen. I mean, it is a confession. It's written in long form. It's not even like they were using gamer code or some kind of secret message. He spells it right out. It's proximate in terms of time to when the crime was committed. The roommate is pushing him for more information, which he delivers. Those are incredibly incriminating. They're going to be big trouble for him if this case goes to trial.
If this case goes to trial, why would it not?
Well, I think there's going to be an effort by his defense team to try to come to a negotiated resolution. The one that pops to mind immediately is, would he plead guilty to crimes and agree to, for example, life in prison without possibility of parole if the prosecutors took the death penalty off the table? We just saw that happen in Idaho in the Brian Kohberger case with the 4 murdered students. And that kind of negotiation happens sometimes. Now, this case is so highly politicalized and of such interest to so many powerful people, I don't know if that kind of negotiation is possible, but the defense might try.
Interesting, interesting. Yeah, so with the death penalty, he now faces the death penalty. If there is no negotiation, how does that change the way the trial would proceed, the case would proceed?
It adds a stage because in these death penalty trials, you have to have a guilt stage, and then you ask the jury, and I believe in Utah, they have to have unanimous decision of the jury to recommend the death penalty for that sentence to be imposed. So you add another stage where the jury is asked to consider aggravating factors. For example, the fact that the gun was fired into a crowd of people and could have hurt or killed somebody else. That is an aggravating factor. And you're asked to consider mitigating factors. And I don't know yet what those are, but the defense would try to come up with something to, share the blame or shift the blame or prove that he was at risk or point out that he's very young. All kinds of things can be brought in the mitigating factor stage. And so in a death penalty case, the jury has to consider all of that and reach a decision on the penalty itself.
Richard Schoenstein is a legal analyst as well, a trial lawyer. Richard, always great to have your perspective. Thank you so much for being with us this morning.
Good to be here.